I would like to have the session resume. We don't want to waste a minute. I'm sorry to interrupt what has been a very successful coffee break. You'll be amused that when I first got the idea of trying the discussion format, I worried, what if nobody talks? And now the problem is, of course, everybody is appropriately interested. And I want to be sure that everyone gets a chance to be heard. So let's start off. I'm very interested in this subject myself. I'll try to restrain myself until partway into the program. We originally invited Henry Ben-Surto of the Philippines to appear here and lead off the discussion. He wasn't authorized to come. And Professor Oxman, at the last minute, gracefully and graciously accepted my suggestion that he initiate the discussion. Then we'll have Professor Dustin Wong from Taiwan. Taiwan has not been sufficiently considered yet. And then we'll hear from Admiral McDevitt and launch the informal discussion. So there's a lot at stake here. We haven't yet mentioned that while this is going on and we're wondering what's happening in discussions between the Philippines and China, Taiwan and Japan are actually trying to make a deal involving the principles we're discussing about Okinatorishima and Taiwan fishing within the 200-mile nautical zone, and it involves a lot of international relations that aren't entirely related to these technical questions that are so important about the law of the sea. We're going to lose Professor Oxman at 5:10 because he has to go to a meeting in Seattle this evening, but I don't want to waste another minute of his time. Bertie, we look forward to your introduction of the subject or elucidation of where we are.
Thank you very, very much. And let me just apologize to everyone. I will simply just try and get up and go when I have to go out and head out to Kennedy Airport. And I'm sorry about that, but I don't want to disrupt the discussion at that point. Let's return to the text just for a second. This is not news to many of the people in the room. Paragraph 1 of Article 121 provides, and let me read it, an island is a naturally formed area of land surrounded by water, which is above water at high tide, unquote. So any feature which is above water at high tide is an island, including so-called sandbar. Okay. Under paragraph 2 of Article 121, an island generates the same maritime entitlements as other land territory, including a territorial sea with maximum breadth of 12 nautical miles, an exclusive economic zone and continental shelf beyond the territorial sea with a maximum breadth of 200 nautical miles, and in the case of the continental shelf, in some circumstances, it could go even beyond 200 miles. Now, paragraph 3, as we all know, adds to all of this, rocks which cannot sustain human habitation or economic life of their own, words which tend to be forgotten, shall have no exclusive economic zone or continental shelf. So it's an exception. By the way, rocks are islands under this definition. People keep getting it wrong, and
But why did they use that word? That's created the confusion.
What
they
word?
could have said islands that or islands which.
Islands could have been of any size. There's an interesting problem as to whether rocks is a totally empty vessel or only a partially empty vessel. The court held that rocks did not mean rocks in a geological sense, and that's obvious because if islands doesn't have any geological limitation to it, then you would have had a truly bizarre result if rocks were limited geologically. So it doesn't mean rocks in a geological sense, but it is entirely possible to interpret the silence in the comments on the Australian claim, which is public, to the Commission on the Continental Shelf with respect to Heard and MacDonald, which exist in conditions to which I certainly would not wish to be subject, that they were just too big. It's possible to interpret that. But we do have a record that there was no objection to the Australian claim in respect of Heard and MacDonald, because you had a whole bunch of states objecting to other parts of the Australian claim, or at least qualifying it. So I don't know, but the word rocks is in there, and some delegations attached importance to the word rocks because they were trying to get at a particular feature that had the word rock in it, which was Rockall, which was claimed by the United Kingdom, and United Kingdom's great friends and neighbors didn't want the United Kingdom claiming a 200-mile zone in respect of Rockall. So who knows? Now, the words naturally formed in Article 121 were central and remain central to the legal inquiry. The tribunal made this clear on two separate questions. One, whether or not a feature is an island, right? Whether it's above high tide, right? And second, even if it is an island, right, to the determination of whether it can sustain human habitation or economic life of its own. And at least in principle, by the way, there was no dispute between China and the tribunal's award on this question. China itself, in its diplomatic notes on Okinawa Torishima, said it had to be the island in its natural state. That is, you were to ignore Japan's buildings and alterations. Okay. Now, the tribunal summarized the situation in this case, right? And we have to be careful. You have to look at the context in this case. The tribunal summarized the situation with respect to the Spratly Islands in China, I remind you, the Nansha Islands, as follows, and I read, China considers that it, quote, has, based on the Nansha Islands as a whole, territorial sea, exclusive economic zone, and continental shelf, right? But China has not explicitly set out its position on the application of Article 121.3 to each of the maritime features identified in the Philippines submissions, which is true. China's general silence in this regard, right? Excuse me for 1 second. I seem to have lost my place. Oh yes, China's general silence in this regard, can be contrasted with the position of states such as Vietnam, Indonesia, and the Philippines, that high tide features in the Spratly Islands are rocks for purposes of Article 121.3 and should only be entitled to a 12-mile territorial sea. B, the position implied in the Malaysia and Vietnam's joint submission to the Commission on the Limits of the Continental Shelf, and I'm leaving the details out, but there is an implication there, because both of those countries drew their 200-mile lines from the areas immediately off the Vietnam mainland and immediately off Borneo, not from any of the Spratly Islands. And C, recent assertions by the Taiwan Authority that Itu Aba, and they quote, indisputably qualifies as an island according to the specifications of Article 121 and can sustain human habitation and economic life of its own, and is thus categorically not a rock. I should then note that after the Taiwan Authority makes this position clear, you're already well into the proceedings when this public statement has been issued, that it's only after that that China indicates that it too regards Itu Aba as a fully entitled island and not a rock. Okay. Now, in light of its entitlement that China's entitlement to EEZ and continental shelf is based on the Nansha Islands as a whole, the tribunal broached and rejected the idea that baselines could be drawn around the Spratly Islands. And it noted, I don't want to get too technical here, that Article 47 permits only archipelagic states comprised exclusively of islands to draw baselines around an island group. And it adds to that, that even looking at that, you couldn't have done it to the Spratlys because they don't satisfy the 9-to-1 water-to-land ratio. So they don't satisfy the objective criteria either. Since the comment was made, I do want to point out, the tribunal was aware that several continental states did draw lines around island groups. My recollection is that all of those claims were or should have been protested by the Department of State. The tribunal found, again, that those claims by continental states were not consistent with the convention. But this would be another area I want to just emphasize, where China clearly could have said it was taking its position in good faith. I mean, Denmark drew them around the Faroes and so on and so forth. You know, this is not, you know. And you can be right, you can be wrong, but there's nothing fantastic about it. Hawaiian politicians have been pressing the United States to do the same for a long time. All right, now, the tribunal also noted China's emphasis on the importance of Article 123 in its diplomatic communications and statements, especially those regarding Okinawa-Tokushima. We've already talked about that, where China insists that Okinawa-Tokushima is a rock, not entitled to an EEZ and continental shelf. The tribunal undertook a lengthy analysis of 121.3 before applying it to the specific features. And I think this is where I want to lay out what the analysis was. So I'm going to take a second to do that. And they make 9 points. Let me just indicate. First, the use of the word rock does not limit the provision to features composed of solid rock. I've already talked about that. Second, the status of a feature is to be determined on the basis of its natural capacity without external additions or modifications intending to increase its capacity to sustain human habitation or economic life of its own. Okay, we've covered that. Third, with respect to human habitation, notice the word habitation. The critical factor is its non-transient character, such that the inhabitants can fairly be said to constitute the natural population of the feature for whose benefit the resources of the exclusive economic zone was seen to merit protection. I should point out here that some of you who studied private international law might notice some resonance in notions such as habitual residence, which is used in private international and on and on. Tribunal didn't cite that. There's no doubt that the judges were aware of it. They didn't cite it, but I just want you to notice that it has to try and figure out what we mean by habitation, right? And it's in fact private international rather than public international that's had the occasion to look at it, but the legal context is different. Okay. Fourth, economic life, and remember it's economic life of its own. You've got a text here. Must be oriented around the feature itself. Economic activity is entirely dependent on external resources or devoted to using the feature as an object for extractive activities without the involvement of a local population would fall inherently short with respect to this necessary link to the feature itself. Okay. Fifth, and this is interesting because a lot of time has been spent by scholars, and in fact we had to do it also in the course of the argument on whether the or was conjunctive or disjunctive, and you could go on forever, and you know, the people who argued that for us I think did an absolutely brilliant job. In any event, the tribunal comes up with the following. The ability to sustain either human habitation or economic life of its own would suffice to entitle a high tide feature to an exclusive economic zone and continental shelf. But, as a practical matter, a maritime feature will ordinarily only possess an economic life of its own if it is also inhabited by a stable human community. For those of us who've studied decisions of important courts around the world, this is not the first time we've encountered a now you see it, now you don't, right? In any event, what they're saying is that as a matter of legal theory, either one of the criteria would suffice to give you a full EEZ, but as a matter of practice, you're unlikely to be able to demonstrate the economic life without demonstrating the habitation. Okay. Sixth, Article 121.3 is concerned with the capacity of a maritime feature to sustain human habitation or economic life of its own, not with whether the feature is presently or has been inhabited or home to economic life. Okay. Seventh, the principal factors that contribute to the natural capacity of a feature would include the presence of water, food, and shelter in sufficient quantities to enable a group of persons to live on the feature for an indefinite period of time. Okay, I think the key, indeterminate period of time. Right. Eighth, the capacity of a feature should be assessed with due regard, and this is important, to the potential for a group of small islands to collectively sustain human habitation and economic life. Thus, they don't exclude the possibility that the capacity of any given feature to sustain human habitation or economic life has to be considered in conjunction with those of other nearby features. I'm sorry? Pacific Island, yes, in Pacific Islands there are those situations. Pacific Island states had made that point in the course of the discussion. Now, ninth, evidence, and this is important because it's a two-stage mental process, evidence of physical conditions, right, will ordinarily suffice only to classify features that clearly fall within one category or the other. All right, so you'll have sufficient evidence on this question, right, if the physical features are clear that you fall into one category or you fall into another category, okay? And we can all imagine that. I mean, you could have a picture of a tiny rock and it's perfectly obvious to everybody that nobody's going to be able to live there. It is insufficient for features that fall close to the line, okay? In such circumstances, the tribunal considers that the most reliable evidence of the capacity of a feature will usually be the historical use to which it has been put. And there they have a very interesting observation. Humans have shown no shortage of ingenuity in establishing communities in the far reaches of the world, often in extremely difficult conditions. Okay. Those are the criteria. I was right, there are 9. And from there, they go on to the physical characteristics of the features at issue. And here, the physical characteristics of the Scarborough Shoal and many of the high tide features in Spratlys leave very little room for doubt, right? Most attention in the decision is focused on the principal features of the Spratlys, including the largest of them, Ituaba, to which we refer. And here, they say that the principal features of the Spratly Islands are not barren rocks or sand cays devoid of fresh water that can be dismissed as uninhabitable on the basis of their physical characteristics alone. At the same time, the features are not obviously habitable, and their capacity even to enable human survival appears to be distinctly limited. In these circumstances, right, the tribunal considers that the physical characteristics of the features do not definitively indicate the capacity of the features. Accordingly, the tribunal was called upon to consider the historical evidence of human habitation and economic life on the Spratly Islands and the implications of such evidence for the natural capacity of the features. We should bear in mind here, by the way, that the Spratly Islands are in a position where they were known for very long, their existence was known for very, very long periods of time. Indeed, a lot of your historical evidence of knowledge of their existence is Chinese. And so this isn't a situation in which you might reach some different conclusion because, you know, you have something sitting there in the middle of the Pacific where you did not have many people knowing even of its existence. I just want to make that point. The tribunal reviews the evidence at great length, and it sees no indication that anything fairly resembling a stable human community has ever formed, Mr. Reichler pointed this out, on the Spratly Islands. It says they've been a temporary refuge for fishermen and transient residents for laborers engaged in mining and fishing. And then they make an interesting point. The introduction of the exclusive economic zone was not intended to grant extensive maritime entitlements to small features if you want some definition of rocks, there's a possible one, to small features whose historical contribution to human entitlement is as slight as that. Nor was the exclusive economic zone intended to encourage states to establish artificial populations in the hope of making expansive claims, precisely what has now occurred in the South China Sea, right? On the contrary, Article 121.3 was intended to prevent such developments and to forestall a provocative and counterproductive effort to manufacture entitlements. Okay. The tribunal similarly decided that the history of economic activity in the Spratlys did not satisfy the requirement that they be oriented around the feature itself. Again, it's the words of its own, of their own. It added, and you may want to bear this in mind, extractive economic activity without the presence of a stable local community necessarily falls short of constituting the economic life of the feature. That's the question. Accordingly, the tribunal concluded that none of the high tide features in the Spratlys is capable of sustaining human habitation or economic life of their own, and therefore such features shall have no exclusive economic zone or continental shelf. I should point out that there was extensive information available on this question, that Taiwan itself had published huge amounts of material that were considered and on which the Philippines was asked to comment and did, and there were huge amounts of information analysis submitted by the Philippines, so that there was a lot of attention devoted to this question. Let me just conclude here by identifying some possible long-term effects of the awards analysis of this issue that some people at least may regard as felicitous. A tempering of disputes over small features at sea and the entitlements they generate. I'm talking generally, not just South China Sea. A decline in gratuitous environmental disruption occasioned by attempts to artificially enhance such features to reinforce claims to maritime jurisdiction. Heightened scrutiny of the destruction of coral reefs, and increased appreciation, I would hope, of the contributions of the Law of the Sea Convention and its compulsory dispute settlement system to the rule of law in international affairs.
Thank you very much. You've given us an excellent background for this. Now we're going to hear from Professor Dustin Wang from Taiwan, who's a leading specialist in international law and who has done a great deal of work on maritime problems. And I want to thank Miss Abby Lee, who's somewhere, oh, there she is, from the Taiwan government, for helping to make this possible. So we look forward to your contribution.
Right.
Dustin.
Thank you. And first of all, I would like to take this opportunity to express my sincere appreciation to the organizer, especially Professor Jeremy Cohen, for inviting me to this wonderful meeting to participate in this roundtable dialogue. I also believe that this is a very good opportunity for me to meet old friends and to make new friends here. So I prepared a PowerPoint. However, it is not completely finished. But just because in the last session, Jerry mentioned that even him has not the opportunity to see the little small features governed by the United States government has already claimed 200 nautical miles of the EEZ. Then I prepared this PowerPoint. I include some of the pictures in it. So probably this is a good opportunity for us to view those small features. So, sorry. I will start with the award, but I only pay attention to the status of features. And, sorry. Okay. First, probably we have to look at the response from Taiwan because I always believe that very very possible that Taiwan is the victim of the arbitration in terms of the two issues. First is the political perspectives, and secondly is the legal perspectives. In terms of the political perspectives, because in the award that we can see Taiwan was called Taiwan Authority of China, I think this is not acceptable by the Taiwanese government right now. And actually, for the legal perspective, that I think most of us, we encourage Taiwanese government to accept the award. However, for the following several reasons that Taiwanese government cannot accept this award. The first is, as I mentioned, that for the political consideration, and secondly, just because the Taiping Island, which is also called Itu Aba, has been downgraded into a reef or a rock. And then this is, in fact, this is contrary to the fact. Therefore, for the legal perspectives, Taiwanese government is not satisfied and cannot accept this award. Sorry. Okay, then this is the response from Taiwan. And I think it is very clearly to state that, what I mentioned just now. First one, we still claim that the Republic of China is entitled to all rights over the South China Sea Islands and their relevant waters. Secondly, Taiwan is not a party to the arbitration. We are not invited. We were not even invited to participate in the hearing. Therefore, I think it is difficult for Taiwan to accept the award. However, being a responsible stakeholder of the South China Sea, as a Taiwanese scholar, we still want to study the award in a very detailed manner. Sorry. Low battery? Okay. Now turn to the article, UNCLOS, Article 121. I think the third paragraph is the main issue, as we had already mentioned that many times. Just because I'm assigned in the section 2 on the topic of when is an island entitled to an EEZ, then what I'm going to comment today is the following 3 points. The first point is a very brief retrospect on the history of lawmaking about this article. And the second point that I'm going to make is a brief comment on the final award of the South China Sea arbitration, especially on the legal status of the features. And then the third one is to look at what the road ahead that we are going to have. Sorry. Okay. Ignore this page. First of all, I'm going to have a very brief retrospect on the history of lawmaking about the Article 121. As we can understand that it is very important to decide whether an insular feature is an island or not, just because the result would decide what kind of rights it could enjoy. In other words, 12 nautical miles of the territorial sea or 200 nautical miles of the EEZ. And this is exactly the reason why the wording of 121, paragraph 3 would be. And let us briefly retrospect the situation in the Third United Nations Conference on the Law of the Sea between 1973 to 1982. Actually, the vague and imprecise wording in Article 121, paragraph 3, has led to sustained and controversial criticism. And look at the legislative history, we can find the physical size of or area of the insular feature in question was a prominent thing in discussion. This issue has generated intense debates as well as multiple proposals from individual states and groups of countries. I don't want to spend too much time on the proposals. However, we still can see the purpose for them to propose. Actually, the size of the population and the area are the two main issues concerning the recognition of an island or a rock. Perhaps because of this, inevitable conflicting national interests dominate the shaping of the regime of islands in that conference. And some of the participants, such as Romania, such as Turkey and Denmark, they were keen to minimize the effect of islands just because doing so would serve their particular interests. And for other states, for example, like Greece or Venezuela, they were keen to maximize potential claims from those small features. And then the ultimate consequence of these conflicting perspectives and proposals was the intentionally vague and ambiguous wording of Article 121, paragraph 3. And that is to say, the current wording is to reduce the political influence through ambiguous and intangible wording. I would like to say, it is very possible that this is the reason why we try to interpret those wording with so much energy, and we still cannot find an appropriate and acceptable for everyone to interpret this wording. And then I would like to move on to a brief comment on the final award of the South China Sea arbitration, especially on the legal status of the features. And first of all, I would like to say it is easy to see that the South China Sea Arbitral Tribunal has already done a great job. However, there are at least 3 or 4 points which are not enough to sustain a convincing ruling. At least for interpreting the wording, sustain human habitation and economic life is questionable. In other words, tribunal has set very restricted conditions on interpreting Article 121, paragraph 3. This is the first point. Talking about human habitation, I quote the wording from the award. That is from paragraph 542. It says that it should be the inhabitation of the feature by a stable community of people for whom the feature constitutes a home and on which they can remain. And what I'm questioning is the stable community of people. From the original wording in the on clause, it only says sustain human habitation. Now comes out a new term, a stable community of people. So the community, what does it mean? We can see from the award itself. The award says it doesn't mean or doesn't care about how many people of the community, as long as they would stay there and treat that feature as their home. However, we still have to think about this question because the size of the population and the size of the area of the feature was the main reason for making this wording ambiguous and controversial. Then we have to come back to the original meaning of the human habitation, but not just to create a new term for the stable community of people. And secondly, talking about economic life of their own, and of their own means they must have the ability to support an independent economic life without relying on the infusion of outside resources or serving purely as an object for the extractive activities. Talking about the not to rely on the infusion of outside resources. The resources could mean the food, could mean the water, but in nowadays, especially in such a globalized world, it is very difficult to find any place which only rely on their own resources. For example, like Singapore, if we have to restrict these conditions, then Singapore would not be an island. Or Manhattan. Manhattan would be another case. So I would like to say this is too restrictive. And let's look at the second point of here. For economic life, it must be local, not imported. So I would like to reiterate again that not imported, it is almost impossible for the modern life. And also, tribunal does not consider the military or other governmental personnel presently stationed on the feature in the Spratly Islands. They are the human habitation. Let's look at the original wording. It only mentions human habitation. It does not mean or does not exclude any status of the human. So from the award, it includes the military or other governmental personnel. It seems to me that the award, or at least the arbitral tribunal, does not take care of the human rights for those personnels. And then the tribunal, I think this is the most arguable one. Tribunal concludes, Professor Oxman also mentioned this just now, as well as in the last session. None of the high tide features in the Spratly Islands is capable of sustaining human habitation or an economic life of their own. Therefore, Spratly Islands cannot generate maritime zones collectively as a unit. Let's come back to the paragraph 283 of the award. It says, it should be noticed that the tribunal says, the tribunal also held that this is not a dispute concerning sea boundary delimitation insofar as the status of a feature as a low tide elevation, island, or rock relates to the entitlement to maritime zones generated by that feature. And also, this is important, not to the delimitation of such entitlements in the event that they overlap. In other words, this arbitration does not concern with maritime delimitation. However, when tribunal conclude that Spratly Islands cannot generate maritime zones, it would create the effect about the future delimitation. So I would like to say the award itself covers quite a lot of area, which is very, at least for me, it is not convincing, and even it is arguable. Okay, so Okay, so let's take a look at the Taiping Island. Not many of us had already been to Taiping Island, but for me, I had been to the, Taiping Island 5 times. This is the situation on Taiping Island. That we can see, it is about 4 to 6 meters above sea level when it is in the high tide, and also sustain the human habitation population over there always more than 120, and the area is about 0.51 square kilometers at the high tide, and it has fresh water supply, and it has vegetation. Then it is, for me, it is very difficult to accept the award saying that Taiping Island is not an island. And talking about the area, it is 0.51 square kilometers. Probably it is not easy to know how big it would be. Allow me to say, for example, it would be just about 1/6 or 1/7 of the Central Park, in New York. Therefore, we can understand it is big enough to sustain human habitation over there. And then, especially with the water supply, fresh water supply, and the vegetation. Okay, let's look at the So what the future will be, and first, I would like to say the peaceful settlement or more conflicts in the future. I'm sorry, I have to say, if we follow the award, probably we would have more conflicts in the future because, for example, there are many countries, they claim the small land features or small maritime features, 200 nautical miles of EEZ, of exclusive fishing zone, or other purposes. For example, like Japan claimed Okino-Torishima, and the United States claimed the Kinmen Reef. They are the small features which can enjoy 200 nautical miles of EEZ. So let's take a look at the picture. This is the Okino-Torishima. Jerry mentioned that in last session, the size of the Okino-Torishima is just about the size of a queen-size bed. It is so small, but we have to take care. It is not the flat one. We have to look at it in the 3D dimension. Therefore, very difficult to sustain human habitation over there, over it. And this is the picture, I get it from the website, that we can see how big it is. And the Japanese government, they even employed a worker to take care of it, just like take care of a baby. And then, okay, this is the Kinmen Reef, which is governed by the United States government. Population 0, area 0.012 square kilometers, no fresh water, no vegetation, but United States government still claims 200 nautical miles of the EEZ over it. And probably it is very deep. It is on the right-hand side that we can see there is a square, a red square on the right-hand side. That is the location of the Kinmen Reef. Okay, it doesn't matter, because it is almost reaching to the end. Okay, thank you. And then I think this is the last slide that I'm going to present. And then what the future will be. Is there any possible cooperation in the future? I would like to say if we are talking about joint development on hydrocarbon resources, then it will be difficult. Why? Because hydrocarbon resources is a non-renewable resources. As long as you exploit it and then or explore it, then it will be non-renewable. And then every country would treat the hydrocarbon resources as the strategic energy or resources, then nobody would give it up. And then it will be difficult for this kind of joint development, especially in the South China Sea. However, the joint cooperation on managing fishery resources, then I would like to say it is possible. It is possible just because, one, fishery resources doesn't care about the boundary. It swings just because of the food, the current, and also the temperature. And then probably we can pay more attention and on that kind of cooperation. And especially in the South China Sea area that we can see the IUU fishing is really serious. And then the fishery resources has already been damaged in the South China Sea. And then I believe this kind of cooperation could be conducted among the littoral states. And that is the comments that I am going to do. And any comments or questions are welcomed. Thank you.
We've heard two detailed statutory treaty exegesis, and it raises the question in international law generally, interpretation of treaties, UNCLOS specifically. Words are empty vessels, and how do you pour meaning into them? What are the policy implications that should lead a tribunal to decide one way or the other? And to talk about policy and even security, we've asked Admiral Mike McDevitt to make some comments from a very different non-lawyer's point of view, and then we'll have a discussion.
Thank you, Jerry. I much appreciate being invited to come here. I would have much preferred to just sit here and learn. I've spent the last 4 years of my life doing research on reports focused on U.S. policy toward the South China Sea and what policy options the U.S. might pursue. I'm not going to go into that in great detail, but from 1964 to 1970, on 4 different ships, I crisscrossed the South China Sea dozens of times, all the way from Haiphong and the northern end of the Tonkin Gulf, all the way around to the Gulf of Thailand, obviously mainly off the coast of Vietnam, but running around throughout between the Philippines. I've actually shot bullets at Scarborough Shoal when it was a target and helped shoo fishermen away when the aircraft wanted to go practice bombing on the way to Yankee Station, et cetera. And we all stayed away from the Spratlys because on the nautical chart it said dangerous ground. And remember, these were the days before GPS, so navigation, if you had a really, really, really good celestial fix, you knew where you were plus or minus 2 miles. In the middle of the Spratlys, if you don't know where you are plus or minus 2 miles, they're liable to name one of them after you. And so, little did I realize 50-odd years later, I would be sitting here talking about the South China Sea and maritime entitlements. What I'm going to do right now is just a couple of thoughts on implications, and I have a few pictures to show. I think 3 of them or 4 of them. I want to, on the Article 121.3, I already indicated in a previous intervention that I thought it was absolutely essential to finally provide some specific clarity on how to separate an island from a real small island called Iraq. But on a lighter note, listening to the 9 points that Professor Exum went through, one of the things that jumped out at me is there are no expatriate Spratlians running around the world anywhere. And so think about that one for a second. Okay. And the fact that there are no islands in the Spratlys, I think makes it much easier to finally reach some closure on overlapping claims and being able to move ahead on joint development. One of the things that occurs to me is that by removing the possibility of an overlapping EEZ created by one of the features, mainly E2ABA, it now makes it easier for Vietnam, Malaysia, and the Philippines to cut a deal. Because no matter what happens with China, all of these other overlapping claims to many of the features, these other 3 countries claim some or all of what China claims. Now, Vietnam would have to make the biggest compromise because they would have to give up their claim to the entire Spratly chain. But it would be possible because now the stakes are so low. You don't get a 200-mile EZ. You only get a 12 miles for fish or maybe hydrocarbon, but you have to maintain these garrisons at great expense. And meanwhile, nobody's getting on with joint development. So possibly, just possibly, Malaysia and the Philippines could cut a deal on their overlapping claims. And then Malaysia and Vietnam could cut a deal on their overlapping claims. And finally, Vietnam and the Philippines could cut a deal on their overlapping claims. Now, China would go crazy. Let's face it, because suddenly Vietnam, instead of having 22 or 23 features in the Spratlys, would probably get most of the Philippine features. So then all of a sudden they could have garrisons on maybe 35 or 40 features. But that would also allow Vietnam and Malaysia and the Philippines to have reconciled their claims and have a, if you will, a united front, may I borrow the word, against China in terms of its claims, and Taiwan for that matter, in terms of its claims. So that's one of the possibilities, I think, now that that is with us with regard to the very felicitous ruling on 121.3. I must admit, though, as I was listening to those 9 points being ticked off, the cynic in me was saying, I can see the tribunal sitting around there tying themselves in knots, trying to figure out how to write E2ABA out of the picture. What do we have to do to get E2ABA out of the picture? And they did it. And so now, let me, I think probably it'd be best if I go up there and point with my finger something. I think most of you know this, but these are the 7 features that China has occupied, 6 of them since 1988 and then Mischief from 1994. China was the last one to occupy features in this Strait. Philippines were first, and then Vietnam and Malaysia. It was a land push. Everybody was busy because they were betting on the come that if you garrison them, the
That demonstrates a very different perspective from the one we were focusing on before, which focuses on the literal language of the provision of the UNCLOS treaty, but it relates to how do you interpret these terms? The Admiral said something before he stood up there that disturbed me a little bit, implying, whether seriously or not, that the tribunal sat around deciding how can they figure out a way to deny an EEZ to Ituaba, as though the tribunal is motivated by political, security, military factors, rather than the kinds of questions we've been struggling with, how best to... Yes, well, I wanted to say that relates to the interesting question we've only very briefly alluded to, which is who were the arbitrators? Paul Reichler rightly said, and I think Bernie Oxman agreed with him, that the arbitrators were 5 of the leading arbitrators in the world with respect to law of the sea matters. But it raises the question, shouldn't China have participated in the selection of arbitrators by picking its own and then joining the Philippines and picking 3 others? And the Philippines, of course, had its own independent choice. And wasn't it a huge mistake, both legally and tactically, politically, for the Chinese leadership or whoever approved this decision to stay out of the process? They could have taken part in the selection of arbitrators and then dropped out. And they could have dropped out at various stages of the proceeding. But I want to reject from my own point of view, and maybe I'm naive, insufficiently cynical, that the interpretation was simply governed by the idea of how do we deny China and Taiwan a 200 nautical mile EEZ for Ituaba. Now, there's a related way to do this. There's the debatable question where we had some difference of opinion. Professor Wong said, if the tribunal had decided the other way, Ituaba deserves a 200-mile nautical, 200-mile zone, there'd be fewer disputes in the future. But as has been pointed out, at least the most immediate effect was by denying Ituaba a 200 nautical mile EEZ, it avoided a major tangle between the Philippines and China because nothing from Ituaba could reach the Philippine EEZ. It created no maritime clash that would have excluded, of course, the jurisdiction of the tribunal. That raises yet another question. To what extent is the tribunal, in interpreting words, swayed by the fact that one interpretation continues to give it jurisdiction and another interpretation denies it jurisdiction? You've got all kinds of factors here. Paul?
Let me say, I listened very carefully to Professor Wang's presentation, and which was excellent. And as I said before, this is the first time that any international court or tribunal has been called upon to interpret and apply Article 121.3. What's the difference between an island that is capable of sustaining human habitation on its own and one that is not? And while on the merits of that issue, I think it's a very well-reasoned opinion, and I think it's right. But reasonable people can come to other conclusions. What I think, though, that is dangerous, and particularly in the sense of probably everybody in this room would favor an arrangement in the South China Sea that assured peace, assured that everybody's strategic interests, including China's, are guaranteed, and provided for the protection of the environment and the sustainable and equitable sharing of the resources. I think, as I said in my opening remarks, I think the arbitral award is a roadmap for that. I think it is not conducive to the end that we, if I'm not presumptuous, all favor here, to impeach the integrity of the tribunal. There are really no grounds for that. I've argued before all of these eminent jurists on a number of occasions. You can agree or disagree with their decision on jurisdiction or their decision on the merits, particularly Article 121.3, but these are among the most eminent experts, honorable people. 3 of them have been presidents of the Law of the Sea Tribunal. 4 of them have served on the tribunal. The other, from the Netherlands, is an extremely well-regarded academic expert. And I think it's a disservice and really disrespectful to them. And I don't think Admiral McDevitt was saying that seriously. I think he was providing maybe a lighter moment to what otherwise is a very, very serious and important presentation, if I may.
In other words, called a smart-ass comment.
Yeah. I mean, I made a few, and probably I shouldn't have said as much as I did about the U.S. claims in the Pacific. But in any event, I think there's no reason to believe that they were guided by anything other than their own view of the law and the facts. You could make an argument both ways. You could, I mean, if you were looking for ulterior motives into how they might decide, and of course, when you're sitting there for 8 months waiting for the decision, you're worried about what they might do, and if you're representing the Philippines, you say, gee, maybe they don't want to decide too much against China because China is China and they don't want to antagonize China. And maybe they'll decide this issue in favor of China so as not to have China reject them or be defiant. You conjure up all of these possibilities. It's only natural. But, and if you're doing that kind of conjuring, you say, well, because a reasonable argument could be made about the status of Ituaba, and because you're doing it against a blank slate, there's no precedent. So they are freer in their analysis of the law and their application of it to the facts. You could conjure up an argument for why they might decide this is an issue that could be decided and therefore should be decided in favor of China or Taiwan. But I think that kind of speculation, which may be inevitable at certain times, I think it should be resisted, because I don't think it helps any of the parties, and I don't think it helps China to discredit the arbitrators or their reason, or their good faith or their expertise. So I don't think that Professor Cohen is being naive or insufficiently cynical. I think you're right. I think that especially knowing these people, they are very, very serious scholars and jurists, and we can agree or disagree with some of the conclusions. But nobody should doubt their absolute impeccable good faith and their efforts to do a very difficult job as best they could.
I wanted to, I'll be within a minute, Julia, just say 2 comments on that. Late in the day, as was said earlier, the China Association of International Law, Taiwan, composed of very good scholars, including Professor Wang and my former student, Ma Ying-jeou, who, despite being president of Taiwan for 8 years, continued to teach international law and has always been a law of the sea person. They put in, not the government, but the Association of International Law, put in a very good brief, which wasn't formally accepted by the tribunal, but which was considered, et cetera. When I read that brief, I thought, well, maybe 121.3 should be interpreted to give Ituaba a nautical, 200-mile nautical zone. But when I read the opinion of the tribunal, I really thought that was more persuasive. I thought it was more persuasive from many points of view. One, textual analysis, historical, legislative history equivalent, investigation into the origins of this. It was really quite exhaustive, even though I recognize Peter Dutton's point about perhaps they should have considered more the question of, look what all the other countries are doing, but I reject that concern. I think that would then make international law provisions the victims of distorted applications by a number of self-interested countries. I found the decision a wise decision in addition to a technically desirable result because I felt it does expand the area of commons, of the free areas open to all countries, instead of giving countries that happen to have a pipsqueak bit of land a huge amount of sea and access exclusively to the resources of a huge area. Now, it's interesting. Before the decision, I and another Taiwan scholar made a proposal to President Ma that Ituaba be turned into a conference site for a neutral consideration of all these issues, a kind of a continuing conference site where scholars not only from Taiwan and also the mainland, but all of Southeast Asia and other interested parties like Japan, the US, South Korea, et cetera, could come and study this question. And people liked that. But in the end, even after this decision, which Taiwan protested, they say it's not possible technically to make this a conference site. You can turn the island into a humanitarian use thing, like rescue of sailors who've run adrift. You can have some limited, but you can't at this point, despite all the development and military transport, et cetera, to the island, it's incapable, they say, of having even a small scholarly community to stay there and be a permanent community. When I read that, I thought the tribunal definitely was right. This Ituaba is just an artificial creation in terms of trying to populate it with 120 people. It isn't the kind of community that deserves a 200-mile nautical zone. But as Paul said, one could be wrong about that, but I am becoming increasingly convinced that the tribunal made the right.
I actually had the responsibility of arguing this issue before the tribunal. We divided up the issues, of course. And let me say before that I thought that the presentation that Taiwan made, including the Chinese International Law Society, was excellent. It was professional, it was first rate, both on the law and on the facts. And the tribunal did consider everything, and it sent everything to the parties. As counsel for the Philippines, we received everything that Taiwan submitted, and we were asked to respond. And so we spent a lot of time, and you put us to a lot of hard work to respond. But looking back at this, and especially seeing what the award is on this subject, I think there was one overarching fact that that I think had the most influence on them, and that is that, forgive the rhetorical flourish here, but this is the way I put it. I said, from the beginning of time until the end of World War II, there was never a human settlement on this or any of the other Spratly features. And these are not in the middle of the Pacific, as one of you said. They're right smack in the middle of an area that has had sophisticated civilizations all around it. not only in China, of course, but the civilizations, the Southeast Asian civilizations in what is present-day Vietnam, Indonesia, Malaysia, Philippines, for thousands of years. So these were right in the middle of trading routes.
Very different from Singapore.
And it makes the argument that if these were truly habitable on their own, somebody would have set up or attempted or had a settlement of people who went there to live and establish a community with the idea of staying there. Now, if that is your test, and I think the tribunal was persuaded to a great extent by that, then it leads you one way. Starting, I think, in 1946 or 1947, the then Republic of China began to occupy, put a military garrison on Itu Aba. And with a small interruption, it's been there since the early 1950s. And I don't know if it's 120 or 200, but there are a considerable number of people who are there, but my understanding, the vast majority, if not all of them, are government personnel. They are either military or law enforcement or government officials or government scientists.
You can't even get there without using
Yeah.
a government
And they
airplane.
rotate. They're not there permanently. It's not as if they said, this is a great place for me to raise my children. I'm going to bring them here and my relatives and invite some other people and we're going to live here. Now, again, that may not be the right test to apply. And we only have one case. It remains to be seen whether other tribunals or courts will follow the interpretation of Article 121.3 that this tribunal gave. And make no mistake, it's binding on the parties in this case. But it may be that other tribunals in other cases will be more influenced by the kind of arguments Professor Wang is making. I don't know. But it's not as if you have 12 cases all aligned. So I think the law is evolving.
Paul, a quick question. The Philippine settlement on Itu, they have tried, they have a mayor there, they got houses and churches, and some of the Vietnamese, whenever, they tried to turn this into a community approach, just a garrison. Was that under discussion at all?
Yeah, Thitu is about the same size as Itu Aba. And the Philippines does maintain a civilian settlement that is intended to be permanent. But the Philippines acknowledged during the hearings that they could not survive without constant support from the outside.
We've got 32 minutes, and we have at least 4 people at this table I want to hear from. And then I want to make sure we hear from others who've been sitting here so long and patiently. Maggie, you haven't had a chance yet. Maggie Lewis of Seton Hall.
Yeah, well, after Tuesday, I might take my 2 children and my husband and volunteer to settle Itu Aba. But in all seriousness, though I have appreciated this wonderful distraction of this fascinating conversation for a few hours, I can't help but think about the implications of Tuesday's election, both Senate and President. And if our topic is the implications of the arbitration award, what are the implications of our election on the implications of the arbitration award? And, first with respect to whether U.S. will ratify UNCLOS, I think the odds were not good before, and I'm not a betting woman, but anyone who wants to take that bet that it's not going to be ratified anytime soon, I'm happy to be the bookie here. And as far as the optimistic long-term view about powerful states seeing that complying with awards might be in their interest down the road when they're on the opposite side, I worry too that sort of long-term view of the benefit of complying with international laws is not going to find a very receptive audience right now in the United States. And more specifically to the South China Sea, that if as is expected, that the United States will be more introverted and in our concerns right now and maybe less focused on the role we might play in the South China Sea, what are the implications there? So I'm in need of a dose of optimism. So I would love for someone to tell me that it doesn't matter that much what the United States does in this calculus of what's going on. But I expect it matters a lot. But I'm unclear about what is the role of the U.S. If there are these crisscrossing bilateral Vietnam and Malaysia talk, are we going to get a web of agreements that might build towards something that is cohesive, or does it become a hot mess of a bunch of bilateral agreements that don't mesh? If the U.S., what positive role could the U.S. play? And if the U.S. does retreat a bit from the South China Sea, how bad is that for the prospects for a peaceful settlement?
I think we'll hear from Peter in 15 minutes. I actually misspoke. We don't have 32 minutes for this discussion. We now have 15 because we want to hear Peter's going to take care of the future when we conclude. But now I want to hear from Lynn Kwok from Singapore.
Thank you. So I'm from Singapore, but I'm not speaking on behalf of Singapore. And in fact, I'm not even going to address the issue of Singapore on this panel unless anyone's interested. On what the US could do, though, that's certainly something that I have thought a lot about, and I think that the US can do a lot. We've talked about the legal aspects of this case. We've also talked about the strategic implications of this case. And I think it'll be great if we could tie them both together, and I think that's where the United States comes in. The tribunal did not decide on issues of sovereignty over these land features in the South China Sea, and therefore, in the Spratlys, and therefore, it cannot clearly be said that China's occupation of these features, with the exception of places like Mischief Reef, it cannot be said that China's occupation of these features is unlawful, nor can it be clearly said that China's construction on these features is unlawful. So where does that take us in terms of limiting a very expansive approach to dominating the South China Sea? And I think the tribunal's decision actually helps in this respect because it makes very clear the sort of maritime entitlements that each feature in the Spratlys is entitled to, and therefore the sort of limits to the maritime claims that China can legitimately assert. So at the very most right now, they can only be asserting 12 nautical mile territorial sea from the Spratlys. And in which respect, I mean, the United States and other countries who are interested in upholding international law should actually be seeking to put their best foot forward in terms of giving teeth to that judgment by freedom of navigation operations that says that China, we're not saying whether you own this. We'll accept that you own it, just for the sake of argument, but you are not entitled to anything more than innocent passage. I mean, you're not going to demand on anything more than you're entitled to. Namely, I should be entitled to innocent passage through these features, and beyond this 12 nautical mile limit, I'm entitled to high sea freedom. So I can have military exercises beyond that, even within the 200 nautical, supposed 200 nautical mile EEZ, because China suggests that military activities within the 200 nautical mile EEZ is not legitimate. But here, that's no longer an issue, and I think countries really should be stepping up to the plate in terms of giving teeth to that judgment, because otherwise it's going to be wasted. It might well be a paper judgment if this step and some other steps are not taken, and I'll leave it at that.
Isaac and then Juliet.
Thanks, Jerry, and I suppose I should retroactively state that I'm not speaking on behalf of the United States government or any agency there, particularly not with what I'm about to say. So just to pick up on this question about the influence of the ward and hopefully try and spin out something positive to make us all feel better. I think sovereign equality aside, any durable political outcome to any of these disputes individually or collectively is going to need to take account of Chinese interests as weightier than the other states. And I know that's controversial, but that certainly is Chinese position, and it is this sort of cynical view. China has bargained very hard since moving into the Spratlys in the late 80s. It's put up a pretty outrageous maximal claim in the form of the 9-dash line, but has demonstrated that it's willing to compromise on that. We've seen that in both the Gulf of Tonkin with Vietnam, as well as in other smaller episodes. And so if Chinese interests are so important to the management or future resolution of these disputes, I think we would do well to get a better understanding of what Chinese interests in this really are. And we've had some really good inputs on this from both Hong Nong as well as Admiral McDevitt. So on the economic issues, are the resources themselves the principal issues at stake? And I would argue that we've heard very clearly from the Chinese that the answer is no. They don't need exclusive rights to all the resources within the 9-dash line. While fisheries and oil and gas are significant, they're hardly a drop in the barrel in terms of Chinese overall demands. It seems totally implausible that they'd be taking on this much diplomatic cost solely for the sake of economic interests. So I think we can safely set that aside. On strategic issues, as Admiral McDevitt points out, they're not complicated in any way by jurisdictional issues. This is a fait accompli. There are major Chinese military facilities on these artificial islands. There's no circumstance under which any state is going to evict China from that space. And so to the extent that those are the main material issues at stake, I feel like there's a lot of room for compromise in China's case, and I'll get to why I think we might see a more compromising China optimistically. And so it seems, from what I understand, what's preventing China from being more accommodating are, some more maybe what we might euphemistically call political issues. And I'm just wondering what's preventing Chinese leadership from saying, we've studied this award and we've started to negotiate with other parties, and we're delighted to report that even this hostile politicized tribunal and this egregious award that contravenes all of our interests was still unable to strip China of its inviolable sovereignty over the Spratlys. It vindicated it, in fact. You could make an argument that, particularly in its decision on Scarborough, by acknowledging essentially China's effective control over it and asking them to graciously allow some Philippines artisanal fishermen to operate there at a very small scale, it takes a step towards really, really affirming that Chinese sovereignty is not under challenge in this award. And I think in practical terms, nobody's suggesting that China is going to abandon its sovereignty claims. So, tell the Chinese domestic audience, tell the international community that this is a victory for China. We'll stay here for another 5,000 years or 20 years, or however long it's been. And I think we've already seen pretty significant and, from my point of view, welcome steps in this direction with regard to the Philippines. And we've already seen Philippines fishing vessels operating in the territorial sea nearby Scarborough Shoal. There continues to be a PRC law enforcement presence that can be all over CCTV. They can shoot a documentary there. They can be heroes. And there's not any reason that doesn't look good to other states, and I assume that's a big part of China's diplomatic mission here, is to demonstrate that if you show up and engage in bilateral dialogue and consultation with us, if you don't throw the award in our face, we're willing to cut you a deal that's going to make you happy. And so to bring it to how the United States being more introverted or, dare I say, isolationist in the future, which is a possibility, I think it opens up possibilities for China to act constructively without being distracted by conspiracy theories about the U.S. backing up all of its allies and partners, which I hope the United States will continue to do. But that's a secondary point here. We've seen in the case of China's land disputes that it has been most in the mood to be gracious and compromising from positions of strength in its territorial disputes. And certainly it has done nothing if not improve its bargaining position and strength in these disputes through island building and just through its through its through accretion, through growing bigger and growing more capable in general, not just building up islands. And so I think, there's a potential opening for China to really demonstrate that it's willing to do what it keeps on saying that it's willing to do, which is to say, we're going to shelve the disputes, and again, sovereignty is ours, 主权在我, and you can tell that to everyone at home, and it'll be true, and there's not going to be anyone who can refute it because no one's actively contesting it. And we're willing to engage in dialogue and consultation on issues of joint development. And I'd be curious to hear what Dr. Hong has to say about it, but also just to sort of throw it out there as a sunny scenario that this award can really be constructive in that way. It can really have stimulated a really nice test case of China's capacity to deal on these issues. Because again, the resources and the strategic issues seem to be in China's favor, and you can negotiate from a position of strength.
I think if one wants to be optimistic, looking at the range of possibilities, you could go beyond that. The only remark that my dear friend Paul made today that I had a question about when he said sovereignty is indivisible. But international law has shown there are lots of ways of dealing with sovereignty disputes. Many precedents, dividing the line, rotating. There are so many possibilities. We shouldn't even underestimate that. But that's undoubtedly politically down the line. Julian?
Thanks. I just a couple of thoughts. One, just going back to the conversation talking about the arbitral tribunal, and I don't have any reason to doubt the impeccability of the tribunal. I do think that China's Vice Minister of Foreign Affairs specifically questioned their integrity, suggested they were being paid and bribed, or at least, really went after them in both a personal and a serious way. So I think the government's on record really questioning the integrity of the tribunal, saying that the Japanese were conspiring to appoint, the tribunal, so that's why they're politically motivated. So I think it makes it even more difficult for China to ever give any credence at all to the arbitral award, and it's and I think also, frankly, it suggests that, that the attitude of the Chinese government is willing to go out and disparage the reputations of International Arbitration Tribunal members. I think that's something that, is a sign that they don't have any intention ever of respecting the award. So I think that's one thing. I think just circling back to the other conversation about U.S. reactions, I sort of want to endorse what Lynn was saying. I think one other option I was thinking about, which other countries could do, but which is sort of like a semi-nuclear option in this scenario, but I actually went through the law and figured out, under existing U.S. law, the U.S. could sanction Chinese companies that do business in areas that the tribunal has decided are, like that building an artificial island on Mischief Reef, which the tribunal has decided is a violation of the award. It would be perfectly easy for a president, maybe not this president, but any president, just to issue the order, and any Chinese company that did business and any Chinese person that did business in regions that were defined under the regulation could be barred from doing business in the United States. Now, I think that would be a nuclear option because then the Chinese would retaliate but I think it is interesting just to explore all the different things the U.S. could do. Now, that leads a lot to Maggie's question, which is, well, will the U.S. have any interest in doing that? And I think American politics are, in this sense, more complex than Chinese politics, perhaps. But I have to say, although I was stunned and shocked by the results on Tuesday, I don't think South China Sea policy actually is going to be necessarily as different, and it might spin in different ways. I think I just noticed that the person that is being talked up for Secretary of the Navy is a former existing Congressman, Randy Forbes, who is one in Congress was very focused on the South China Sea issue, right? So we actually may get too much attention to the South China Sea and not enough perhaps on other issues, but I think there actually might be a lot of appetite in the new administration for focusing on this issue. So
I agree with that. I think Trump may surprise people by having a more, not less, robust policy, and that could be worrisome. Randy Forbes is a big spokesman for the defense industry, and we have to worry about the implications.
a really big Navy is what he wants.
Yeah. Well, James, some final wisdom before?
It's quite a thrill, for me to learn. Thank you, Mr. Richard, and also Professor Oxman. I've learned quite a lot. This is quite educational. Few points, very brief. I won't take your, too much of your time. Number one, I think in response to Margaret's point, my colleague, my close friend, Professor Ling Bing, made 40 minutes remarks about the implications, impact of the arbitration award in Taiwan that took place 2 days ago. But finally he said, all I said about is based on the assumption Hillary is going to be the president. So I think this is also the mindset I think I have right now. So I'm quite concerned about this the political process that is very dramatically developing in this country and its impact on this part of the world. Secondly, I think the impact also the implications of this award on China is enormous in that I think my country does need a process of re-examining its own behavior before, the middle, and in the end of this arbitration process. In that is that as Professor Jerry Kun just said, I am still afraid to call him Jerry, Professor Kun. As a smart to sort of give up your procedural rights, if you participate in the arbitration, that it can enjoy to sort of, to make your points heard, not only by the arbitration, by the tribunal, but also by the international community, particularly in matters of jurisdiction. Professor Oxman, I think, made the point. We all agree with that. The military, activities. One. A very possible point to argue about the jurisdiction of the tribunal. Secondly, I think China, is also faced with the challenge of, changing the mindset about this third-party dispute settlement mechanism, international legal system. I made it very clearly. Certainly, China feels very dissatisfied with today's, rule-based international system in that particular respect. But the point is, if you want to change it, you have to participate. If you don't participate, it won't be able to change it at all. This is the second point. Thirdly, we do need to educate our people what international really means is operational aspect. International, well, if you take international from rule of law perspective, particularly this third-party, settlement mechanism, sometimes you have to, you have to be able to afford to lose, as Professor Cohen, used this example of Indian Premier Modi said, So I made it very, Xu Hong, Xu Hong. So when I talk this case with my, foreign ministry friends, say, James, Professor Lee, we cannot afford, we cannot afford to lose. I said, I hope someday China can afford to lose. When?
Now I've got,
Okay, sorry.
now I have to go catch the subway to take me to the Amtrak and take me home. Yeah, that's right. Just a couple of quick points. We need to be careful in terms of U.S. policy and Lynn and I have had this conversation before, a freedom of navigation operation is not intended to be a deterrent operation. We've got to be very careful that we keep the freedom of navigation operation focused on excessive claims as the physical manifestation of a diplomatic protest about an excessive claim, as opposed to saying, give me 20 pounds more of fawn so I can deter the Chinese. The key point for U.S. policy that's the most important statement the Obama administration has made over the last 8 years with regard to maritime issues is the United States will sail or fly wherever international law permits. The important thing about that is, when you think about it, it has an edge to it. It really says, we're going to sail and fly where international law permits, and if you don't like it, you're going to have to try to stop us. And the burden of escalation is upon you. And so the USS Stennis Carrier Strike Groups this spring spent 63 days steaming around Scarborough Shoal, acting as a deterrent, because the Department of Defense was convinced, and the White House was convinced, China was going to build on Scarborough Shoal. Whether they were or weren't, the U.S. government was convinced they were, and China did not. Now, President Duterte has changed that whole dynamic, and happily, I should say. But the point of it is, sailing and flying wherever international law permits really captures the essence of what the U.S. is going to do and continue to do. And I expect, because Mr. Trump's China advisors are all, include Mike Pillsbury, for example, are very hard line on China. So if you combine what he's talking about doing with regard to trade, with combining with some of the hardline security guys, the U.S.-China relationship may get a lot worse in the future. So, and with that, I have to run, so.
Last word before Peter Dutton. Lynn Kwok has a two-finger addition.
I think all I wanted to clarify was that freedom of navigation operations, as it's framed by the Department of Defense, is to challenge excessive maritime claims. That usually works in most situations, this notion of challenging excessive maritime claims. However, in the situation of the Spratlys, where China's claims are actually not clear, you don't know, there are no clearly excessive maritime claims to challenge. So I think it's a bit of an unfortunate wording, because what in fact the Defense Department is doing by these FONOPs is in fact just exercising the maritime rights which are vested in them under international law. So, and that works better for the Spratlys, because in fact all they're doing is to sail and fly as international law allows, as permits, as Mike Dibitz said. And just one point on Isaac and the United States being isolationist and maybe that being a good thing. So as the only non-Chinese Asian on this table, I would like to say that that would be a terrible idea for the United States, not least because as the founding father of Singapore once said, Asia is not a movie that you can, press freeze and then go back to and hope that nothing has changed. I'm not advocating that. Yeah. And also, I don't believe that being able to sit back and let countries negotiate is necessarily inconsistent with a policy of engagement. So the Assistant Secretary of State, Danny Russell, recently mentioned that that the Philippines it's a very good thing that the Philippines is negotiating with China, because also it puts the United States under less pressure to defend the Philippines should something go wrong. So I think definitely the United States needs to keep its eye on the ball in Asia, because especially at this moment, all countries in Asia are watching the United States very careful for early indications of its level of engagement in the region. Because it's making a calculation right now whose camp it should park itself more firmly on. So I think the U.S. plays a pivotal role at this moment. Thank you. Thank you.
Good. We have a request from a representative of the Republic of China on Taiwan. I didn't say the Taiwan government or the authorities on Taiwan. I'm trying to use a proper name, please.
Well, first of all, I'd like to thank all the speakers for this stimulating discussion. And I would also like to say that this case is really enlightening for many participants or many stakeholders involved. And I'd just like to add 2 points to Professor Wang's presentation. First of all, the vague wording of Article 121 is an ultimate compromise of debates. And the court had to find, the criteria convincing enough in order to make a just ruling and on how to define an island entitled to EEZ, and which I admire very much for their efforts. However, these criteria are not convincing enough. If you really look at each of these criteria, you will always find counterexamples. And however, if we really need to put all these criteria together to qualify or disqualify a feature to be the island, and that might lead us to believe that the ruling may simply wants to disqualify the biggest feature in the Spratly Island, which is the Taiping Island, to be the island in order to make everybody else quiet. And earlier in this session, we also heard that a decision has to be made on Taiping Island in order to make the case between Philippines and mainland China move forward. And so I really have to say that Taiwan is a victim of this case.
Yeah.
And the second point that I want to make is that we were not invited to be part of this legal proceeding. And, but at the end of the day, this ruling needs to be applicable to Taiwan, depending on who you ask. But it's really hard for us to, this is especially true when the government extends invitation to all the judges to come to Taiping Island to see for themselves. And it's really hard for us to digest and the outcome of this ruling. And so, unfortunately, these judges decided to rely on indirect or third-party resources to make the ruling, and some of which were meant to lead the way, to think. So in this regard, I have to say that Taiwan is the victim of this ruling, and Taiwan finds it very hard to digest. Thank you.
All right. We've gone over time, but the conclusion awaits us. Appreciate your patience, and now we can hear from Professor Dutton, and I'm genuinely eager to hear how he is going to summarize this.
Yeah, thank you. Well, I couldn't possibly begin to summarize it, but I think the first thing, and I hope you won't mind if I can address you all this way. The first thing I'd like to do is thank Jerry Cohen. What a really tremendous and stimulating program. So thank you very much. And I would be remiss if I didn't thank Paul Reichler and Bernie Oxman, Hong Nong and Dustin Wang, all who worked so hard to prepare their presentations and remarks and to enlighten us today. I do have to say that all of my questions and concerns have been answered except one. Jerry Cohen mentioned earlier about, he and I apparently have a bit of a disagreement about this question of Article 121. And it's really, in my view, not about cynical national perspectives about, how much water space can we grab and can we generate if we claim an exclusive economic zone. There are actually countervailing humanitarian, really, interests, and those have to do with protection of the environment. But remember that the exclusive economic zone is not specifically just about capturing the resources, but about managing the resources and about preserving and protecting the environment. And there is a really good philosophical argument that says that expansive exclusive economic zones might be appropriate as the best way for states to manage, to have an interest in, and therefore to manage the resources and the environment. So that one question hasn't yet been discussed. Maybe some other time we can take it up. One of the things that I thought it was worth summarizing is, what is the value of this case? After all, what is the value, having been through this process? What is the value of it? I think Hong Nong did a great job of raising that particular point. She specifically reminded us that it has facilitated negotiations between the parties of in the South China Sea. And specifically, we've observed it's not just Philippines and China that are now again talking. It's the whole region talking. CUES, the Code for Unalerted Encounters at Sea, and the various agreements that have been the code of conduct in the South China Sea. All of these things have been moving forward, I think, with a little bit more press since the case was started. Additionally, of course, it's also clarified all sorts of areas of the law that have been simply begging for it. We really didn't know what Article 121 was meant to be. And I think the single most important thing to say is that this case has facilitated negotiations on the basis of the law. So even if China, like Russia, chooses not to formally acknowledge the case, as Professor Cohen talked about in the Arctic Sunrise case, there is actually movement forward on the basis of the law. And that alone is a very positive thing. So we have demonstrated, I think, that the tribunal made a very careful and balanced application of the law, despite my provocative questions in that regard. And what we have seen come out of it is something that can help guide other states as they're making decisions about these issues. And I want to point out that this particular case really, as we just heard from the gentleman from the island of Taiwan a few minutes ago, this really has brought up the really difficult situation that Taiwan finds itself in, and I think we should all reflect and attend on that particular point as well. So we do, I think, have a reason to continue to reflect on the question of balancing a sovereign state's prerogatives and this international dispute resolution process. Like Hong Nong, I studied both international law and international politics. And I think one of the things that I remember in a case like this concerning China, it's, as I said to some of our friends at lunch, it's so easy to judge because it's so hard to understand, right? So easy to judge because it's so hard to understand. And so the key is more understanding and less judging. That's the key. That's a good way of living our lives, but also a good way of interacting together as states. China is a state in search of dignity. We have to keep that in mind. David Kang, a noted political scientist from the United States, has opined that in the West we think about sovereignty in the sense of formal equality among states, when in fact there really is an informal inequality. Look at the states of NATO. Not all states are equal, he points out. China looks at it the other way around, David Kang says. He says, really, there must, in China's eyes, be formal inequality. I'm reminded of the statements of Dai Bingguo in Taiwan, or in Singapore, when he reminded some states around a table that they are smaller than others and they need to get used to that idea. But, David Kang points out that when China in fact interacts with other states, once that informal inequality is acknowledged, it treats the other states with an informal equality. And that's an important thing to keep in mind. Chinese behavior regarding the arbitration, both during its pendency and in the period after the decision, we can understand a little bit better if we keep that in mind. Because once the Philippines came to China at the end of the arbitration and agreed, in fact, to bilateral negotiations, progress was made. But critically, progress was made based on the decision's basis. I think that's the benefit of international law, which had not been happening before, a very positive outcome. And I will tell you, I personally believe that it wouldn't matter whether it was Duterte or someone else elected to the Philippine presidency. I think this process would have been undertaken, perhaps with a little bit less rhetoric, either way. So was the case a good idea? Emphatically, yes. We have now the benefit of clarity and the facilitation of negotiations. These outweigh, in my mind, the challenges. I think Admiral McDevitt said it quite clearly. It's easier now for states to negotiate together and to cut a deal. He did a great job, I think, of reminding us that law exists in context. It does not exist separately as words on a page of paper. Law exists in context in the South China Sea, states with interests, trying to protect those interests and to live with their neighbors. Finally, I'm reminded that today, this afternoon, has been the Gilad dialogue. It would be remiss if I did not refer to Timothy Gilad, who devoted his professional life to China's efforts to develop a modern and respected legal system. China has come a long way since Tim Gilad worked with China and until his untimely passing. I think it was 24 years ago, if I'm counting correctly. So even, and I would say it's come even further since Jerome Cohen and Steve Orleans worked with China to bring them into, to bring China into the system of nations and to help them establish international law practice. Not only do we honor Tim Gillat's work today, we honor Jerry Cohen and Steve Orleans and their work as well for what they've done to help China get to where it is today. So the question we end with is, how do we carry on Gillat's work? How do we integrate China now, not only to develop its own legal system, but to integrate that legal system into the international legal system? I think the South China Sea arbitration provides an instructive first step. China did not participate, but may comply. I think that's the key. What can we do now to encourage them and to help them to do so? What should we do to give dignity also to Taiwan's circumstances? The arbitral award is a roadmap for a lot of legal and political matters. It is time now for us to roll up our sleeves and to carry on Timothy Gillat's work, to develop understanding about the law and about how states pursue their interests, and to improve China's legal relationship with the United States, with us, with all countries, and China's relationship with the law. Thank you very much.